I would like to pass it over to our moderator today, Jenna Minifi, and start today strategic value master section.
Thank you, Jenny. Thank you so much. And for all of you out there that are listening, if you would please, excuse me, put into the chat where you're listening from. Where are you calling in from today? Because it's always fun to see where everybody is coming from on this. Anyway, thank you everyone for being here today. Thank you to our panelists for being here as well today. As I always say, you always have choices about how you can spend your time. And the fact that you are here today with us in this webinar today, it really is an honor to have you here because you do have choices of how to spend your time. And the fact that you're doing it here with us today, we so appreciate it so very, very much. So let me get started by letting my panel introduce themselves. Gretchen is coming into us on our on the Zoom here today. So Gretchen, why don't you go ahead and introduce yourself, and then I'll introduce everybody here in the room.
Sure. I'm Gretchen McCord. I'm a business law and trademark attorney. I run a virtual law firm. I'm actually in Central Texas, but all the rest of my people are spread all over the country. And we provide fractional general counsel services, which is kind of like, larger businesses have in-house general counsel that manages all their legal work and it brings legal perspective to the business's planning and operations. We do that on a part-time basis for small businesses is a good way to think of fractional general counsel. And we also do a lot of trademark work. Trademark is basically brand. So we do a lot of brand protection work.
Gretchen, before I go on, would you, so I know I like to bring it up every time that we use the word fractional. Explain fractional, because I don't think everybody understands what a fractional lawyer is.
And it really is someone who either in law or in other areas, because there are a lot of fractional professional services or professional service providers. So fractional HR person, for example, or fractional marketing. It's just a position that you would want. If your business was big enough and you had the budget, you would want somebody inside your business providing this, being a part of the business that does the legal work for the business, that's in charge of the marketing for the business, that takes care of the HR department in the business. But as a smaller business, you may not have the need for a full-time person doing that work, and or you don't have the budget for it, or usually the two go hand in hand. And that's where fractional services come in. And so my firm does fractional legal, but like I said, fractional services in all sorts of different areas that support business.
All right, thank you so much. Hey, would you like to introduce yourself, please?
Yes, hello, I am Cote. I'm the founder of Amplify EDM. I help artists to build their platforms in the dance music space. I'm also a podcaster with Action Coach here in Central Texas. And so I get to talk to entrepreneurs across the whole area from a variety of different backgrounds. And so that's a little bit about me.
Yes, and this is your first time here.
First time here.
And it's same with Albert. This is your first time with us today.
Thanks for having me. My name is Albert Carion. I'm an intellectual property technology transaction attorney. I work mostly in the software space. I also prosecute trademarks and provide general outside counsel services to my clients that I've represented many years, and they just come to me with all different kinds of things now. So aside from technology, so happy to be here and happy to talk about trademarks.
Yes, something you probably talk about all the time.
That's right.
Yeah. Well, and you do too, Kate, because when you're working with musicians, that's real important when we talk about patents. But before I jump into that, oh, darn, what was your name again?
Good morning.
Good morning.
I'm Bill Thompson, Associate Director here at the SBDC. I see clients at the SBDC.
A whole lot more than that. Because Bill and I have been working together, I think it's 14 years now.
14 years.
Yeah, that we've been working together. So yeah, we like to have a lot of fun, unfortunately. Yes. And so we tease each other constantly. Right. Well, I do the teasing.
You gotta get by it.
No, you're very nice. Anyway, I'm Jana Menifee. I'm going to be the moderator here today. And what I do is I do business valuation. So anytime, like for small businesses, if you're trying to bring on a new partner, you need to have a valuation done to decide what that equity value is worth. If you want to put your business into a state, then you need to have a valuation done for the IRS, and I do that. If you decide to get a divorce, I do that too, if there's a business involved. And in those type of cases, sometimes I get to go to court, and I love going.
Good.
I know I think that should be my tagline, and I love going to court. Let me go to court. It's so fun. Anyway, so let's get started. All right. So before we get into like all the details of everything, let's just get understand intellectual property basics. So Gretchen, we're going to start with you. So start with the fundamentals. What are the different types of intellectual property that people need to consider in their small business?
That's a really good question. The term intellectual property is used, sometimes misused. It's really accurately, sorry, my phone's going off, really accurately an umbrella term for about 4 different categories of intellectual property. One is trademark, which has been mentioned here already. And trademark is basically a brand. So anything that you use as a brand to identify your product and to help consumers understand that when they see that brand, they know that whatever the product is coming from the same place that that product did before. So yeah, my husband and I go back and forth with our favorite peanut butters. He likes Jif. I like another one that I won't name. So, the reason for that, they're both peanut butter, right? Peanut butter is peanut butter, but to him, one tastes better, to me, the other tastes better. That's trademark. Copyright is protects something that you create. So it's anything that the requirement for copyright is that it have whatever you've created have a modicum of creativity, and that's a very low bar. What I say is it means that something has to have sprung from your little head, as opposed to you're reciting a fact or you're copying something that someone else has done. So the third major type of intellectual property protection is patent protection. And that protects, typically we say inventions. That requires a very high level of novelty, meaning some part of what you've created, you've invented, has never been done before. Some aspect of it has never been done before. And then trade secrets is the other category of intellectual property protection. And each one of these protects something a little bit different, and provides a different type of protection. For example, trade secrets protect something only as long as it's literally kept a secret. So, there are these stories about how the Coca-Cola formula is like divided into 3 different sections and kept in a safe, and each one in a safe in a different state, so that nobody really knows the formula. That's a trade secret. Once that becomes public knowledge, no protection there. So a copyright gives the owner of the creation, book, movie, song, art, any kind of artistic rendering, gives them the right to prevent somebody else from copying what it is they've created, making derivatives, which is a new work based on that one. So it could be copying it and changing it a little. It could be something like a sequel to a book or a movie. It gives the owner the right to keep someone else from distributing copies to the public, and kind of making it accessible to the public. So public performance or public display of the work. And trademark gives the owner the right to keep someone else from using a brand that is not necessarily exactly the same, but close enough to my brand that on a good or an association with a service that is similar enough to the thing, like the peanut butter that I make, that consumers might mistakenly think that the two are somehow connected. For example, Dove soap and Dove chocolate, exactly the same trademark, but they're two totally different products, because nobody's going to mistakenly think that the soap people are making chocolate or the chocolate people are now making soap. However, if you wanted to start selling a cookie under the trademark Dove, that would be an issue, because it's logical to think that the chocolate people are making cookies. So that's kind of the scope of the 4 different categories or pots.
I love that Dove example. That was great. Thank you for that. Albert, so for a small business, when they're starting to think, we're just getting started, say, what is the first IP that they really should be thinking about in terms of a small business and protecting it?
Um, I think the trademark is typically the first thing that they encounter because they want to identify their business, right? And I think it's important to think about it as something that's going to last potentially as long as you own that company. So it needs to be a very considered decision at the outset. And one of the things that we may talk about some common mistakes later, but one of the mistakes I see small businesses make is that when they get their corporate name from the Texas Secretary of State, or they file an assumed name with the Texas Secretary of State, they think that that alone grants them exclusivity or the right to use that name as a trademark, as a brand, but it doesn't. And if you look at your certificate that you get from the Secretary of State when you get your corporate records back, it says the issuance of this certificate does not authorize the use of a name in this state in violation of the rights of another under the Federal Trademark Act. They're just saying, we're just giving you this corporate name. We're not saying you can go out and use it as a trademark. So that's a common misconception that a lot of small business owners are under, and they say, hey, somebody else is using my corporate name, and that's where we got to talk through this warning and all this other stuff. But the main thing is that it's important because of the things that Gretchen said, but it's important also because it protects the good name that you create under that trademark, right? You create an awesome coffee brand or a puzzle. I have a client has called Project Genius, and they make puzzles, right? So their brand is very important to them. And when they make good puzzles, you make good coffee, you want whatever brand that you're associating with that coffee and puzzles to resonate with consumers, right? And so that they know that when they hear, American, your coffee name, that's Gretchen's coffee, or that's Janet's coffee, and I know what it tastes like, and I know how much it costs, and I know where to get it. Okay, all of that association is called goodwill. Okay, and that's what trademarks are designed to protect. And it's important for small business because the identification is what grows the business, right? When you do good service, you create a good product, you want to earn the benefit of that. And so the trademark protects that. The trademark gives you exclusivity in that trademark so that nobody else can use it for similar goods or services, as Gretchen mentioned. But it also protects your investment, right? You're building something, and you don't want to lose that over time. Because when you come to sell that business, I think it's very valuable if you have your registered trademark and you've got that goodwill protected, and that is transferable to the buyer in the form of an increased price for the business, right? So that's why I think it's an important thing from the beginning to think about it. The second reason is if you make a mistake there, if you don't do your homework and vet this trademark,
Exactly.
right? And let's say you decide you're going to call yourself Armadillo Coffee, right? You register your corporate name, you buy signage, you create a menu, you build your business model around this name, and when you open, 2 weeks later, you get a cease and desist letter from somebody in Cedar Park who already has a business called Armadillo Coffee, right? You didn't do your homework and look to see if that name was already taken, or check with the USPTO records to see if there was a registration for Armadillo Coffee. And now you've lost that investment. And that's a huge expense for a new business. And I've dealt with that situation so many times where right when they're getting going, they have to rebrand. And it's deflating. It can kill the business at the outset, right? Because people start saying, well, this person doesn't have their act together, right? I just started going to Armadillo Coffee and now they're called something else. So what happened? So that's why I think it is very important, and because it's ubiquitous, and not everybody has a patent, not everybody creates something copyrightable. Almost every business has a name that they want to protect and be identified with, and that differentiates them from somebody else. So
Yeah, and I think that you brought up a really great point, is making sure you do your homework, and don't do your homework just in Texas. Look at other states as well. Do an internet search, right, of that name. Does anybody else currently have that name out there? But don't think just because you register in Texas that you're safe, because nobody else in Texas has that name. It could be already registered someplace else. And I think that's so important that when people do that, that they look for it. I can get the domain name, so it must be mine.
Right.
No.
Yeah.
Yes. So don't start there. So what, all right. So I've started 2 nonprofits in my lifetime. And one time I started my nonprofit, we decided to do the trademark ourselves. That was such a mistake. And I would just like to tell everybody, if you want to get a trademark, go to a lawyer, have a lawyer do it. Because if you just try doing it on your own, like I did years ago, all of a sudden, every online lawyer is saying they're going to help me, or somebody else is saying that is my name, or whatever. All these people, all these cockroaches come out on the internet and come after you. So please go see a lawyer, do your trademark when you're starting your business, do that. Right. And so, Kate and Albert were having a great discussion before we even started this webinar. And I kind of like to jump back into that conversation a little bit with you, Kate, is that you're in the music industry, right? And in the music industry, there are a lot of things that people have to think about in terms of IP. And you were discussing that earlier with Albert. Could you go over that again? Because our guests were not with us at that point.
Definitely. So yes, in the music industry, there are so many aspects that are important for an artist to have set up legally to protect their intellectual property, their music, whether they're collaborating, if they're getting a label deal. There's so many things to think about. So a few of the big ones must have agreements as a split sheet. That's just to start. But unfortunately, a lot of artists only think a split sheet is necessary. What that is.
What's the split sheet?
Yeah, I was just gonna get into that.
Right.
So that's when you're co-writing a song with another producer, another person. Maybe it's somebody who's doing lyrics, somebody doing a melody. But what that covers is the writer percent splits and the pro info. So who controls the publishing contact info. And so it's really what artist is contributing what. And so that's a split sheet between them. And then the master ownership agreement, again, that's like the sound recording of the track. And then the producer agreement, which covers the fee, the royalties, the credit, whether it's the work for hire. So artists need to know at least those 3, and that's just the beginning. And so that's where a lot of artists come in, and we were talking like artists just want to make music, and they don't know where to begin. They're maybe fearful of talking to a lawyer. So I guess kind of like what I would ask as like an advocate for artists is how can they get started without feeling that overwhelmed, or how can they really like protect themselves?
I mean, I think they have to make that investment. I mean, because, if you're playing music and you're wanting to do that in order to make a living at it, right, then you've got to be able to sell those records. You got to be able to perform those songs, have the right to perform those songs, and eventually try to get it streamed or pressed into an album. And when you come to your an album or a record company, they're going to want to say, show me the proof that you own this song, right?
Yeah.
If you went into a studio with 8 musicians and you created this song, how do I know those 8 musicians aren't co-authors of this song? And you're just one of them. So just having the agreements when you come to create a song that you're going to own all the rights to it, or your band is, maybe your band sets up an LLC and all your rights get transferred to that LLC. That LLC contracts with the record company, the streaming company, with the album producing company, or the artwork for the album. So it just creates, I don't know, it solidifies your ownership. And that's important because bands get together and they break up all the time. New people come in, new people come out, and it gets confusing over a while. And I mean, if you just want to play music because you like to play and you don't want to make a living at it, it's a hobby. That's one thing, I guess. But if you're wanting to try to make a living at it, you need to think of it as a business, and or somebody needs to be thinking of it as a business if you're not going to, like you, hiring you, who can connect them to the right people to protect that investment that they're making.
One, coming back to your point from earlier on talking about brand. I'm sorry, Gretchen, I'll come right back to you. But brand, right? The musician has a brand. They have a type of sound or whatever, and they need to protect that somehow, right?
Right.
And so that's something. Gretchen, you were going to add something.
I was just going to add that the law is often not logical. So that, you know, in combination with everything both of y'all were saying is there are so many pieces to this is kind of the point. At one point, I think Kay and Albert were making, but on top of that, what you think would be the case, like you think if I do this or I and Kay do this, then we both own it. Maybe you do, maybe you don't. I mean, the law is not logical, so you can't make assumptions.
Now, when you go into a studio as a musician, does a producer already have these contracts already, and then you just put it in front of the musician and say, sign here? Is that what normally happens?
It really depends on like how, like a lot of artists will just go into a studio together, produce something, and then they're like, where I run into the problem is they go into that mentality and they're like, oh, we will deal with the legal when the song takes off. So there's a lot of problems there because they're not building the house from the foundation. They're building up here, and there's no strong foundation with their legal. So that's something that has really been a struggle in the music world, is they're just like, we just want to get in the studio and create, and they don't have those parameters set in place.
And you know, that's so common in small businesses, right, Bill? When you're working with small businesses, is they go, we'll worry about the contracts and all that kind of stuff later. And then they come to me, and then I get to tell them how to do the valuation instead of them deciding how their business. So you see that a lot, not just in the music industry, but with other small businesses that you work with.
Yeah, across the board. When I was reading the question on this, I was thinking about this. I was thinking about for technology clients or advanced manufacturing clients, in that basically the financing is what I do. And before your pre-revenue, how do you finance it? Because you're not going to be able to get a bank loan. And so we're looking at equity lending, and then how you're going to do equity lending, get the longest runway possible without giving up 100%, over 51% of your company. And so that's really what I focus on is on the financing side of how to get them financed. And you've got to have those agreements in place, or it's a nightmare. Nobody's going to touch it if they don't have the agreements in place.
And do it before there's money.
Yes.
Do it before there's money, because as soon as money comes involved, everybody changes.
Yes.
All of a sudden, it's a whole new ball game. So do it before, because you see, I see it all the time. You know, especially because I see partnerships break up, and they come to me to do the valuation to decide on the equity. You know, and it's just like, well, we've always been good friends, so we never did that. We just always thought, you know, we'd work it out together. Well, no, because then they break up, and then one of the partners wants to destroy the business. And when they take their equity out because they don't like the other person, and they're this working together is no longer there. So it's so important to get those contracts in place before anything happens, right? So important. So let's jump to talk about a little bit about protecting your brand and the ideas. So what, Albert, I talked a little bit about this earlier when I said about my nonprofit, and I try to do the trademark myself. Yeah, don't do that.
Yeah.
So what is the right way of getting a trademark?
I think the important first step, and where I think a lawyer provides the most value, is vetting the mark that you want to select, that you want to, you know, choose as your trademark. And as Gretchen mentioned, it's not identical. It doesn't have to be identical. That somebody doesn't have to be using the identical mark in order for you to infringe. It could just be a similar mark, or in similar goods. Going back to the Armadillo coffee, let's say there is an Armadillo World Cafe. Okay, they also sell coffee, and they're using it before you're using yours, right? They also sell coffee. They also cater to coffee consuming public, and they sell other things. But they've got the word world. Well, that's a court could consider that and say your subsequent use of Armadillo coffee is likely to confuse people because they sound the same, they sell kind of the same thing, they're kind of catering to the same channel of business. So that's where a lawyer can bring value and say, you should probably stay away from Armadillo coffee. There's this cafe out here. And that helps protect it helps you from going down the wrong path too early, saves money, right? That you don't have to rebrand. And so the lawyer can just having that lawyer with their experience, with their knowledge, and just help you choose the right name. And don't, you can start with one name or sometimes give them 2 or 3 names, so, you've got some options. So that's the first thing. But once you decide to file, I always recommend filing with the U.S. Patent and Trademark Office, which gives you kind of more of a national registry of marks, so that that process can take about 10 months if everything goes well, right? So when you file your application, you've got to decide: am I going to file as a word mark? Is it just going to be Armadillo Coffee, just the typed words? Which is a really good application to have because it would protect any stylization or any font or color the way you use that mark. Or am I going to follow just as a design? It's going to have an armadillo, and that's all it is, right? That would be a design mark. And then you can have a composite mark, which is the armadillo with the word Armadillo Coffee. So you got to decide that at the beginning, what's going to be my brand, and you can follow all 3 of those, right, too. So then you got to pick your services, and it's $350 per class of services. So you file that, and it's not going to get picked up for about 4 to 5 months. You'll get an initial review, and the examiner will say, yeah, I think you're entitled to this mark, but you may need to clean up these 1 or 2 things. You may need to disclaim coffee because you're a coffee company, you sell coffee. Or they may say, there's an Armadillo Cafe registration, and that's going to block your use of Armadillo Coffee is likely to confuse people, so we're not going to give you this, grant your application. So you've got to make counter arguments to try to say why that won't create confusion, and that's where a lawyer can help you, right?
Yes, yes. I was just thinking, yes, make sure that you go have somebody help you that knows what they're doing.
And they're called office actions, which is kind of a funny name. But you have 3 months to respond to those, and if you don't, your application can be dismissed. And that's where I see a lot of, pro se people doing it on their own. They get the office action, they don't know what to do, they don't know whether they want to spend the money on a lawyer, and then 3 months goes by and it gets dismissed. And so having a lawyer at the outset who's going to keep track of that docket and get the office actions and talk to you about them, decide whether it's worth responding or going a different route, So, but assuming that everything goes well, if the mark will get published for opposition. It means anybody who reads the Federal Register will have 30 days to oppose Jana getting her name that she wants, and they have to have reasons, and they have to show that they would be damaged. So nobody files any opposition, then you get a registration. And like I said, that takes about 10 months. It used to be quicker, but patent offices had a lot of turnover. There are not as many people working from home, and it's just the process is slower. So that's kind of the overview of it. There's another one key tool that I think businesses can use is what's called the intent to use applications. Historically, you had to show you were using the trademark before you could file an application. Now you can say, hey, I'm planning this business and it's going to be Armadillo Coffee, but I'm just at the outset of it. But I can go file an application right now, and it's called an intent to use application that says, hey, I intend to use this mark later on, but I want to get it going through the process. And if it's valid and not taken already, you will get what's called a notice of allowance. And then you have 3 years to use that mark from the notice of allowance. That's plenty of time, right? Now you've gotten your notice of allowance. You've got more confidence in building your business around that name. So, and that's also a deterrent effect, because if somebody sees If I'm counseling somebody and I see somebody has already filed for Armadillo Coffee, even if it's an intent to use application, I'm going to say, hey, somebody's already filed. You're not going to get your registration granted while that one's pending. So you can either risk it and see if that one registers or not. If it doesn't, then yours a second would come in, right? But likely it will. Let's pick a different day. So
it might be telling you something. All right, Gretchen, we've talked a lot about trademarks, but there's other things that within a business that we want to protect as well, like our customer list and other things. So what other things should small businesses doing besides, all right, we've talked so much about the name of the business, but what else do we need to think about?
Anything that is contributing value to the business. So if the business is, with Kay here, if the business is creating and producing, performing music, anything associated with that. So the actual things that you've created, the songs, somebody referred to artwork on an album, whatever provides value to the goods or the services that you're offering. So if it is your client list, if it is your employees provide value, your independent contractors provide value. Every piece of your business is contributing something to the business. That's why you have it there, right? And the way it's a very general statement, the way you protect most of those things is with contracts. If you've got contractors working for you, if you have employees working for you, you want a contract in place with them to protect the business, to make sure that. So I say that contracts serve a couple of primary purposes. One is to make sure that both sides have the same understanding of what's going to happen in this relationship. What are my responsibilities? What are your responsibilities? What am I getting out of it? What am I giving to you out of it? Because nobody goes into a business relationship thinking things are going to go bad, right? They do for a variety of reasons, but often it's simply misunderstanding. So that's one important purpose of a contract. Another important purpose is to protect relationships. So especially if your small businesses are often working with family and friends, right? And I can't tell you, and I know that Albert has heard the same thing hundreds of times, and probably Jana has too. Oh, we don't need a contract. We've been friends since first grade. We're
Yes.
best friends. We see each other
Yes.
every day. We don't need a
Yes.
contract. That's
And then
exactly
we see them in
why.
court.
Yes, exactly. That's
Yes.
exactly why you want a contract. You get that contract so that if things start to go south, there is kind of like you can kind of treat it like a mediary, or kind of like a middle person that it's not my fault. That's what the contract says. Just let's just take a look at the contract and see what it says. And if you're still in disagreement, then you've got something you can take to a true intermediary, to an attorney, and say, what does this say? So you're not getting in that. It really, truly is a way to preserve relationships. But really, what you need to think about protecting is what brings the most value to the business. And we do a lot of work with clients prioritizing. So we do, as fractional general counsel, one thing we do is work with clients to integrate a kind of a legal strategy into the business planning, because the number one reason most businesses fail is a lack of planning. So we want to get that legal piece in there too, because as I think Jana mentioned, most people, especially smaller businesses or newer businesses, don't come to an attorney until something goes wrong. And I guarantee that's going to be a lot more expensive than starting with an attorney and trying to prevent something from going wrong. Sorry, I got off track on where I was going with that. But just the things, prioritizing. So part of that strategy thing too is prioritizing what needs to happen. You're a new business, you may have a dozen different things from a legal perspective that a lawyer would say, if you've got all the money in the world, here's what you need to do. But you don't have all the money in the world, so let's prioritize that. And you can do that yourself. Just from getting back to Jana's original question, what needs to be protected in the business is think about, okay, what is most important to this business? What if something goes wrong, or if I lose something or something, somebody asked a question about protecting recipes in a family food business as trade secrets. Is that the most valuable piece of your business? It may be for that business. Then that's the one you want to prioritize on protecting. So kind of think of it that way. If something, what can go, lawyers are always thinking about what can go wrong. I mean, I'm a very optimistic person that you really have to when you're working on things, right, Albert? I mean, you have to think what can
Yeah.
go wrong and how do we prevent that from happening? So think about that yourself. What's the worst possible thing that could happen to my business? If it's burning down, then insurance is a top priority. What's the second worst thing that could happen to my business? Somebody gets a hold of our secret family recipes, then protect that. What's the third worst thing that could happen? Somebody steals our brand, protect that. Just kind of think in those terms if you can. And it may be kind of hard to do, but brainstorm with your people and just kind of get in that mindset, I think is a good place to start. Albert, I'm sure you have something to add to that.
Yeah, I think independent contractor agreements are really important
Yes, they
because a
are.
lot of businesses, when they start out, they can't afford to hire an employee, right? That's just too much to undertake. So they will hire somebody on a contractor basis, and it's important that spell out the things like confidential. I'm going to hire Janet to help me 10 hours a week on sales. That there's a confidentiality provision in that contractor agreement that says you're going to keep my customer list secret and not use it for your own. You're not going to tell anybody about it. You're not going to tell anybody what my internal price list is. That protects those sort of things. It's also going to say how I'm going to pay you, right? You're going to get paid X amount on every sale that you make, so that later on you can't claim you were an employee and entitled to wages an hour and follow a wage and hour claim with the Texas Workforce Commission, saying you were really an employee. But also, if you invent something, you create something for the company, the independent contractor agreement can say you assign all of your rights in the trademark or the copyright or whatever you created for us to the company, so that when you leave, you don't have a claim to it. Okay? And that's all that is vested in the name of the company. So I think the story, which is a really good one, is about how Nike, they hired a freelance person to create that swoosh logo. And I think they paid her $350. But they got a copyright assignment for that logo. And it became probably the most recognizable logo ever. But just assume that they had not gotten that copyright assignment from her. And she had just done it freelance. She could have held them up for millions and millions of dollars, right? Claiming she was the author of that swoosh logo. So just having, they did it the right way at the beginning, and look how much that saved them potentially. So,
And
$350.
that's a good example of how the law is not logical. The
right.
copyrights, as opposed to other intellectual property types, copyrights are owned by the human as a starting point, owned by the human who creates them, unless that person is an employee of the party that's using the work. So that means that independent contractors, unless you've gotten a written assignment to the company, you can pay an independent contractor $5 million to create something. But if you don't have a written assignment assigning it to your company, then the independent contractor actually owns the copyrights in it. And that is something that intellectual property attorneys see all the time, is that misunderstanding, because it's not logical. I paid you to create this. We both intended that my company was going to own it, but that's what the law says. So that's a really good example and a really common example of where problems occur, of why it's important to talk to lawyers as early on as you can.
If I could add one more thing, a lot of people, when they're creating their own brand, they will go to a clip art, a stock photo.
Yes.
All of those things are licensed, and you look at the fine print, it'll say you cannot use this drawing or whatever for commercial purposes, or to apply for a trademark using this, because they want to keep reusing it, right? So if you create your trademark from that stock image, then you really don't own it. You just have a license to it. And if you try to go to apply for a trademark and you get it, and then you try to enforce it, somebody could find out that you really don't own that, right? And it just muddies your ownership rights. So don't rely on those clip art images, and
Now
don't pull off
AI.
don't pull off things off the web. That when we talk about going to Google Images and finding a photo that you want to use or a design you want to use, all of that stuff is owned by somebody else, and you've got to think of it that way. And then unless you get an assignment of rights or a license to use it the way you want to, you could get a cease and desist letter. And there's a lot of attorneys right now who get hired by artists to go and run spiders. They just comb the web looking for a single image, and they will find it anywhere on any website, and they will do it on a contingent fee basis for that artist and send out cease and desist letters.
Ooh, I have a lot to add to this too. When it comes to artists and especially in the dance music space, they do a lot of sampling. So they're taking other like pieces of other songs and applying it to their song. And a lot of times they just do it. And you know, when you hear a lot of dance music, you're going to hear a beat or something. You're like, oh, that's familiar. And so how can artists in that capacity equip themselves to do it the right way, because they're using these tracks, they're performing these tracks, they have these samples that aren't done properly or legally. What are some ways they can go about getting that done properly?
This is kind of a specialized area of copyright law, and I can give kind of a high level answer, but not a very detailed one. Albert, is this something that you have more familiarity with?
Totally, probably about as much as you. I
Yeah,
mean,
it's
it's
it's a complex area of copyright law, and it's kind of constantly evolving, I feel like. Um, it
well, it's like for copyright, you got to prove somebody had access to this work, right? And that they copied it. So, one, did they have, if you think somebody stole essence of your song or it's a beat from your song or lyrics, copied your lyrics, you got to show that they knew about it and that they intentionally and that they took it. But what it, there's a substantial similarity of how similar is what they took to what you own, or what they're doing to what you own, right? Some beats are just like a continuous 1/8 drum count. Nobody can really own that. But if there's some stylistic part of the drumming and you pick up on that stylistic part of the drumming, and it's enough to constitute or detract from the fair market value of the original owner's copyright, then they can sue you for that. So, and that's what, when you hear that sampling, what everybody wants is the hook, right, from the prior song, and because it's recognizable. And so when somebody takes that small, it may only be 15 seconds out of the song, a 2-minute song,
or
but
less.
or less, right? But if it's the hook and it brings to mind this other work, then they can be sued for, the owner can sue the second user for copyright infringement.
And
So,
there's a lot of gray here too. Like
yeah.
in recent years, the Marvin Gaye estate has been really litigious in suing over what they consider to be copyright infringement cases, and some of those cases have been kind of the way they were just what the court decided has been kind of controversial. And then what was the Robin Thicke song?
Oh yeah.
That's
Blurred lines.
Blurred
Yeah.
Blurred
lines.
lines.
Yeah.
Thank you. I kept thinking lines. Yeah. The Robin Thicke and who else was it that did that song now? I'm just totally blanking. Mondays are not good for me. They were sued and I mean, to me, the clips that were alleged to be infringed, it didn't sound like it to me, but the court originally thought different. It's just there's just a lot of gray. It's just a messy area right now. There's a lot of gray going on. I mean, if you just want to, kind of maybe have fun, but maybe scare yourself too if you're a musician, just Google something like copyright lawsuits music and take a look at all the it's fascinating. It's really fascinating. But this is one reason why I just kind of stumble on this, because I think so much of it is really very unclear, because there's so much subjectivity to it, I think, really, with sampling. I think there's so much subjectivity.
Yeah, and I've heard of really big artists. I know a friend of mine, she's best friends with a very well-known artist with his wife. And she intercepts any music that is being sent to him for him to listen to, and she immediately sends it back and does not allow him to hear any of it.
That's common.
Yeah, because they want to make sure that they are not sued later on for, oh, you stole my song that I sent to you, right, type of thing. And so she's really careful on stuff like that.
That's why a lot of producers, artists, people would say, hey, we listen to my cassette, tried to give them music. They'd say they'd turn it down because they don't want to have that in their possession. And then later on that person comes, that sounds like the cassette I gave you. And I really didn't do anything, but they can show they gave you this cassette. So they'll they don't want it for that reason also.
Yeah. Bill, did you want to talk here? It's just like all of a sudden, you and I are just sitting here going, oh my gosh. I'm just sitting here going, yeah, I need to update my independent contractor.
I think I just dated myself by talking about cassettes. Maybe nobody knows what those are.
Coming back. Yeah. Coming back.
Yeah.
45s.
Yeah, 45s. Yeah.
Yeah. You probably don't remember it.
No.
Me too. My parents had all the records. Yeah, and the 45s. Yeah, we had an 8-tracks, everything.
Tracks, yeah.
8 tracks.
Oh my God. Oh my gosh, yes. So, hey, from a music standpoint, what do you tell your artists? How do you tell them to protect themselves?
This is a great question. The first thing I do is because my education, I give them is more on the branding side. I also have like preferred partners that I send them to for further education. And I tell them straight up, like, do this the right way. Because if you have to think about the end game, that you're not just in this to make music. You have a goal in mind. So we establish right away, what is your goal in music? Do you want to work with sync, which helps them get connected to selling their music to like commercials, for example? Some artists just want to do that. Some artists really want to work with labels. That's their goal. So the first thing I do is I establish what's the goal with the music. Then I get them connected with the folks that can help them make that well-rounded and secure. Like I said, build the house from the foundation up. So that would I tell them right away, like if you want to, you want to be a headliner, you want to be producing your own music, you want to work with other collaborators, you want to be touring, okay, that's your goal, then these are the steps you need to do before that's even a thought. Like even before you start making music, or even with the music you've created, how are you going to protect and secure that music first? And any collaborators that you work with. So I really help them look at this like this is a business. And that is like number one for me, for them.
Bill, so we've been talking about, like all these different types of contracts. Can somebody come to the SBDC? Do you guys have like a portfolio that you can say, here's a copy of an independent contractor that we would suggest? What do you do when they come to you about these things?
We do not represent ourselves as attorneys.
No, but you don't have like a standard form that you can give them. So
no, people that come to us, our fees are prepaid by the tax dollars, so they charge for our services. Sooner or later, you got to pay to play. And the quicker you get an attorney, a CPA, insurance agent, the better. And I don't know of any expensive way to go about it. I'm not a fan of online legal systems, because when you wind up in court, they're not going to be there. And so I recommend that you get an attorney. Yeah, they're expensive, but it's more expensive if you don't do it. It's like the analogy I use, you're going to go on a trip and you're on your ship or your boat, you're in a harbor, there's no rough water. You start sailing across the Atlantic, you hit a storm, you're going to sink. And so you need to have somebody to help you patch that boat. Patch it before you leave.
coming from the avid fisherman.
Yeah.
So my great nephew was having a birthday this week.
Uh-huh.
So I asked him what he wanted for his birthday. He's getting a fishing rod and real.
Oh, cool.
That's what he wanted for me for Christmas. I mean, for his birthday. But I thought of you immediately. I should have ran it by you first before I bought it.
That's all right.
No. Yeah, Gretchen, I saw you reacting to what Kay was saying. It was just like your head was just bobbing up and down.
That foundation is we talk about what we do in the kind of similar terms sometimes is, you're building a business, you want to start with a strong foundation. And if you don't, then part of what we do, a lot of what we do is help that business as it's growing and realizing maybe they shouldn't have done everything DIY, as Bill was just saying, go back and strengthen that foundation, fill that in before you continue building on it. Yeah.
Yeah, I think that's so important because what I've seen with startups is not all the founders are aligned on how all this is going to play out, right? Some of them, maybe one business owner is in it for the long term. I want to start this business and I want to run it for 20 years. Maybe the other founder wants to have an exit event or sell it within 5 years, right? There has to be some alignment on how that's going to happen. How is this relationship going to end, right? Also, what's your role in the company? Are you the developer of the software, and this other partner is capital partner? They're going to give money. So their role is to pay, yours is to develop. Maybe the developer is going to put more time into it, right, than the other one, and that can create schisms. So knowing that this is our relationship from the beginning, I'm going to do this, you're going to do that, and you're going to do this. These are all the things that we're contributing, and this is what we're all working to. You can get some alignment on that, because most of the businesses I see that don't succeed, or not, it's a common problem, is that founders suddenly have different ideas on where they want to go. They're tired of spending money. The product hasn't made it yet.
Yeah.
They want to sell and get out of it now, whereas the other one wants to stay in. And then they have different ideas over the value, which is where they hire you, right?
Right. And yes. And then as you were talking, I was just thinking about that. I am working on I have a client right now that I'm working with, their lawyer, and coming up with how to do the value of the equity, whether it's going to be fair value or fair market value, and showing them what the difference is in terms of how they're coming up with that value. So yes, I do work with attorneys and helping them come up with those contracts, because not everybody understands the difference. Because when you do have a partner come on and off, you don't want to kill the company. Right. And so you have to have other things. And so another thing that is done is I usually will push for like a fair value, and then ask and tell them they need to get life insurance policies to cover the rest. So that if something does happen to a partner, they're not going to get that big of a buyout, but it's not going to kill the company. But that life insurance policy will also make up a difference that the spouse would be expecting from that business instead. So there's ways of working through this to help protect that. So we're starting to get near the end of our time, and we haven't even gotten to like one of my pages of questions here. But one thing I always like to end on is asking, what is one takeaway you want someone to take from this? So we'll start with Bill, because that way we give our guests, because I was going to answer that question, right?
Yeah.
So what is the one takeaway that you want everybody that's listening here today, and those that are going to hear it later on? And by the way, at the very end, Jane is so awesome. She is going to be, we love her. If it wasn't for Jane, these sessions would not go nearly as well as they do. But we will be sending out everyone's contact information. So if you do want to follow up with anybody after this, you certainly can. So we will be sending that out at the end. So that's usually a question that people want to know. So Bill, what is the one takeaway you think that everyone should get from this session here today?
From working with many small businesses is to hire the attorney early and not wait. Even in the formation of whether you're going to subchapter A, subchapter C, limited liability partnership or corporation, get with an attorney and understand what the limits and the boundaries of those are. And trademark as well as copyright and intellectual property is right in there.
Hey, what about you?
For me, it's for the music industry, for artists, creatives, but creatives across all industries, and business owners a lot of times are creative people. That's why they're conceptualizing and thinking of these things. But the biggest thing for me is think of your creative project as a business right away. Because if you're going to
Yes.
build something, you're going to grow that passion, grow that fire, build it right so you can continue to grow and keep the momentum going and not have the hiccups down the road that can cost you a lot.
Albert,
I mentioned it, just having alignment on how, on the business at the very beginning, and assume the business is going to succeed. And that means doing things the right way, hiring an attorney, you know, dotting your I's and crossing your T's from the beginning, because it's much, much more expensive to fix a problem than to prevent a problem. So, and it doesn't seem that way at the beginning because your money is tight, but when things go south, and there will be obstacles, it's nice that you have the mechanisms and the company agreement to how we're going to define market value, how this person is going to be taken out of the company, how we're going to bring in new people. Having that decided at the beginning is just, you know, you could avoid so much
priceless,
litigation,
right? It's priceless.
and lawsuits and things that the company just can't overcome.
And Gretchen, what's the one thing?
Yeah, Kay took mine, so I'm just going to do a variation on that. And that is, I mean, you do have to think about it as a business, but so my variation is you know, if you're starting a small business, especially if it's kind of a side gig for you, you know, often what we see is people think, well, you know, I want to get this going, and if it looks like it's going to succeed, then I'll start spending some money on it, basically. But you undermine yourself when you do that. You really, really do need to think as much as you can like a business person from the get-go. And I think to me, it would be, I'm trying to think of a good analogy for this. Kind of part of another analogy for just what I was saying earlier about contracts would be, you don't buy a house thinking it's going to burn down, but you buy insurance in case it does. You know, you don't go into a business relationship thinking it's going to burn down, but there are things that you want to put in place in case, I won't say it burns down, but in case a little flame starts, right? Or you see smoldering going on. And you just really have to think about not just getting the product out there and then it will sell. You have to think about, what does this look like as a business? It's in the professional services fields, we talk a lot about how law school doesn't teach you to be a lawyer. Architecture school doesn't teach you how to run an architectural business, you know, that kind of thing. We know how to practice our craft. You know how to make your product, whatever it is, music or food or whatever. It doesn't necessarily mean you can run a business on that. And it's that mindset that you really have to figure out.
Oh,
I was trying to look at them. So
oh, sorry.
yeah.
That may be
Thank
the
you,
same thing that
everybody.
Kay said.
I was
I know.
just trying to look to see. I hadn't shared my screen, so it shouldn't have showed up. I was trying to see what our strategic value master series was for next month, and I can't remember what it is right offhand. And I was just trying to look that up really quick. But anyway, thank you everybody for being here today. Really appreciate you taking time to be with us here today, because we know that you always have a choice of how to spend your time, and you chose to be with us today. So thank you everyone for being here today. And have a great week. And if you're in the Austin area, stay dry, because it's wet out there. Thanks, Jane.
Bye. Thank you, Jane.